Can't apply to the.
Your Lordship, may kindly see
proceedings.
fifth. Your Lordship, may kindly see the fifth line, fifth para.
Yes.
Sub para 5, my lords.
So offences alleged.
A complaint which does not comply with any of the foregoing provisions of this rule shall not be entertained.
The offences alleged are under the BNS.
BNS, not under this.
My lord, once the complaint is
You
made,
can't import this into that.
no, what I'm praying is, if a complaint is made and it is bona fidely made, then the police will register an FIR and all those things will be done with the procedure for.
No. This is a separate complaint. That's a separate
Every
complaint.
complaint referred to in sub-rule 1. Sub-rule 1 says what? Any person making a
To
complaint.
the state government.
To the state government. That
Or
is
any
not-
officer empowered
This
in
is
this
not
regard by
the complaint by state
this
government.
procedure will not apply for registration of a criminal
I'll satisfy your lordships.
complaint.
In this case, the complaint has been given by some villagers. Not the state officer has made a complaint.
It is not to the state government.
After inquiry, only the FIR has been lodged, my lord.
The
Lordships may then, my lord,
State government.
Lordships may, my lords, then see have, my lords may kindly have page, Lordships, I am praying, your Lordships may kindly have page 44 of my bail application in the Sessions Court, and this I have.
You have two past cases also.
Yes, my
You
lord.
have two past
That
cases.
even then also they have not disclosed it in the SLP.
But they are
my lord.
not disclosed.
Yes, my lord.
Whom?
In the whole SLP, it is not disclosed, my lord.
That you have two past cases.
Yes, my lord. Although there is a special mention in the High Court or Honorable High
The
Court.
order itself, it's mentioned.
Yes, my lord.
My lords, I'm just trying to convince this honorable court. Your Lordships may kindly have.
In the SLP,
My lord,
have
he is not
divulged it.
cooperating, not even giving the documents, my lord.
Just answer the question. please.
I'll answer.
In the SLP, did you mention it?
I'll mention everything, my lords.
No,
Where?
my lord.
May kindly
Show it to us.
Your Lordships may kindly see page 44, my lords. Page 44.
No, in the SLP, you can't say that I mentioned it in one of the additional documents while there.
This is my complaint.
Show us that from your SLP, where
Please,
you
but-
mentioned.
Your Lordships may, my lords, kindly bear with me for one.
We are trying to bear with you. Please show us from the SLP.
I'm trying to show, my lord. Kindly bear for me for 1 minute, my lords. Page 44, your lords. In between, my lords. My lords, I belong to the Samajwadi Party, the ruling party, MLA. my
Not
lord.
on the merits of the matter.
Sorry.
The reasons are, my lord, day after day
We
after
have
day.
asked you
Day after
one
day after day, my lord,
specific question.
FIRs are lodged against me.
Have you disclosed in your special leave petition that you have two past cases? If you have, show it to us, please. Where have you said so? The order records it. Did you mention it in your SLP?
My lords, I am on bail on those cases, my lord. Those cases have nothing.
Counsel, we are asking you a specific question. Did you disclose it? Did you not? Yes or no? Obviously, it's a no. If you're not, then Manish Kumar, we find that though the impugned order specifically records the fact that the petitioner has two past criminal antecedents, no mention of the same has been made in the special leave petition. In the light of the law laid down by this court in Manish,
My lords, those cases are of 2005.
such non-disclosure is
State
fatal
charges
to the
at
case
five-
of the
2005
petitioner.
cases.
The special leave petition is accordingly dismissed on this short ground.
Unless I am praying, your lordships, my lords.
Please look up Manish Kumar if you've not looked it up.
My lord, then I withdraw this petition, my lord.
No,
Otherwise,
don't
these
allow withdrawals.
my lord, these observations will come against me, my lord.
This is on that short
My
ground.
lord,
So
the
there's
reason
nothing
is,
more.
my lord,
Counsel,
2005.
your matter is over, please.
My lord, then I am praying, my lord.
No, we don't allow withdrawals. You appeared before us often enough to know that.
My lord,
Yes. Next matter. Item 8.
Obliged, my lord.
Appearing in item number 8, my lords. My
Yes.
lords, in this case, charge sheet has already been filed and the accused is in custody since July 24, my lords. There are around, my lords, 16
Cases
witnesses.
of ganja.
Yes, my lords.
And
50
you're
cases of
saying
money.
that the trial has commenced, but no witnesses are examined.
Uh,
Charge sheet is filed.
Yes, my lords.
Charge sheet
As
was
such,
filed long ago, according to you. 20th September 24.
yes, my lords.
Until now, the trial has not commenced.
My lords, as per my instructions, the trial has not commenced yet. And there are around 15 witnesses in this
Told
case,
you
my
to
lords.
that, because we'll issue notice only on that ground to
Uh,
find out why the trial has not commenced.
My lords, and kindly give me a short
Are you
pass over.
standing by that?
I will confirm this.
No. If you're not standing by it, then
My lords, may kindly give me a short pass over. I'll just confirm this from my client and get back to you. My lords, has the matter been passed over?
Pass over.
Oblige, your lordship.
May it please, my lords.
Yes.
My lords, this is for bail, my lords.
Hmm.
So I am inside for 1 year, 3 months, my lord. Charge sheet has been filed on 7th of April 25. There are a total of 14 witnesses.
To file a suit for cancellation?
Yes, my lords, I filed a suit earlier, my lords, and then it's a counterblast. They filed an FIR, my
But why
lords.
did you file it to cancel the document?
My lords, because actually because of the transaction, my lords, they were saying with a very less amount, my lords.
Very well. We'll
So I
issue
filed a
notice,
suit.
Mr.
In fact, the FIR is also belated. The allegation is
We
of.
are issuing notice, Mr. Kosh.
I am so grateful. My lords, liberty to serve the standing counsel, my lords.
The council is there.
Very well, my lords. If he's there,
They
yes.
condone. Issue notice returnable on soon. Mr. Ankit Goel and council. Accept
So
notice
grateful,
by
my
the
lords.
state. Service shall be effected upon respond number 2 by all modes including Dusty. List on 14 July.
My lords may have it in partial working days also. It's a bail matter. It will appear, my lords. It's a
I'm not working, so it's not fair on my part to visit
very well,
you
my
upon
lords. Very well, my
my
lords.
brother judges may
Great.
happen.
Very well, my lords.
I don't know it. Date in the partial working days.
Grateful, my lords. Grateful.
But I don't have the. June 15th. 15th is also Monday. Monday.
Grateful, my lords.
I said 18th, I think, no?
My lords, the listing is on 18th of June, my lords. My
Sorry?
lords, the listing on.
You want it on 15th or 18th, Mr. Ankit?
My lords may list it on 15th. my lords.
Yes,
15th.
but if it could be the 19th or 20th June, Lord.
No, I am not. Just before
Oh.
15th, my lord. Just
All
before
right.
15th.
19th is a Friday.
In any case,
19th
it's
is a
it's through VC, my lord. We'll do it.
No, not 19th, my lords. May have it on 15th, my lords.
15th is okay, my lord. In any case, it's through VC. I'll appear.
Yes,
What if-
15th, my lords.
It's anyhow only VC, is it not?
Yes, yes,
Partial
ma'am. Yes.
Grateful,
Sorry,
my
ma'am.
lords.
Yes.
10.
May it please, my lord.
We've already
I
dismissed Pawan Batoria's matter. You are identically situated.
Annexure P8, page 128. The manner in which
You are identical to Pawan Bhadoria. In fact, both of you together joined and filed the petition before the High Court. We've confirmed that very same order in relation to Pawan Bhadoria, so you'll have to follow suit. Nothing more to be said. Delay condoned. However, we find no good ground and reason to interfere with the impugn judgment passed by the High Court, especially petitions accordingly dismissed. We're going much slower.
after some time, my lord may grant, if trial does not progress, after 6 months, my lord may say 3 witnesses have already
Very well,
been
at this
examined.
stage, you see. At this stage.
Upright.
11.
Yes, my lords. My lords, it is now more than 1 year since the High Court had
But
granted
you
me.
have 6 past cases and
Yes,
you are in
Lord.
the habit of stopping people on these rural roads and extorting money from them.
My lords, I was arrested on the
With 6
statement.
past cases, what do you expect us to do?
My lords, in this case, I am on bail in all those cases, my lords, and in
But
this case,
obviously
I
you're
was.
not learning a lesson from the fact that,
My lords, I am willing to learn my lesson, my lords.
no, where's the question?
My lords, in this case, my lords, one submission, my lords, in this case, I was
You want
arrested
us
on.
to treat this as your 7th deadly sin and let you off after this, is it?
My lords, this would be
Okay.
my last case, my lords, in that sense. My lords, I was arrested on the statement of one of the co-accused, my lord. There is no recovery from me, my lords. My lords, there
No,
is.
not at this stage. Considering the past antecedents, don't say that otherwise. We find no good ground and reason. to
My lords,
interfere with the
I am in
impugn
jail
judgment
for
passed by
more
the
than
High Court.
1 year and 5 months, my lords. I am
At
in
this
jail.
stage, at this stage, we've said, so you spend a little more time, a little more introspection. The special petition is accordingly dismissed.
My lords, may I renew this bail after 6 months, my lords?
We said at this stage, so we are leaving that door open.
Highly obliged, my lords.
May it please the Lords. My Lords, item 12. My Lords, charge sheet filed, my Lords, maximum is 7 years, 119 witnesses cited, my Lords, charge and charges also not been framed. And
Very well. Issue notice, returnable loan. This can wait till after. You've been inside since December. Not even
Since
December,
December.
January practically.
but
31st
yes, my
December.
Lord,
You went
31st.
in on New Year's.
But my Lord,
Give
the
you a date in
director,
July.
the
Mr.
people with
Abhishek
the
will give you a
direct
date
link-
in July.
my Lords, immediately on the reopening, if my
Yes.
Lords will.
15
Thank you,
July.
my Lords.
I am accepting
Grateful,
notice,
my
Lords, on behalf of
Great.
the state.
Someone's taking
Grateful, my
notice?
Lords.
I am accepting notice,
Yes,
Lords, on
Mr.
behalf.
Padmesh Mishra.
Grateful, my Lords.
Obliged.
Grateful.
Yes.
But with your Lordship's permission, yeah, well, intermediate quantity was 20 grams. 20
Little louder.
Yes, Lord.
Little louder.
No, it was 20 grams of intermediate quantity, Lord. Not from me, from the house, Lord. And I'm only the daughter. I'm only the daughter.
He was inside a locked room.
Locked me inside the room.
No. From the inside you had locked it.
Outside also it was locked.
And you and your mother made a hue and cry about the search being carried out.
Obstructed the search.
Obstructed them.
Please been granted.
There's other provisions, 221 and 132 BNS are also there.
Not against me, Lord. That's not against me.
Heroin. But still.
All other accused have been granted bail, Lord. All other.
But,
I placed.
Seem to be drug dealers is the conclusion
Lord,
drawn.
I'm only 24 years of age, Lord. Now I've turned 25. And 1 year I've been in jail, Lord. I'm grateful, Lord.
Notice.
I'm grateful.
Notice returnable on same date in
Yes, Lord. July, Lord.
July 15.
End of July, Lord. Your Lordship.
So you want end of July?
By such time, I'll have completed some Lord's and also.
Very good. 30th July.
I'm grateful, Lord.
So we
Deeply
should be
obliged.
affected by all. Anyone taking notice? Item 12. Not 12, 13. 13. Go on. Issue notice.
Item 14, my lords, I am appealing on behalf of the petitioner, my lords. This is a petition for regular bail. There was a theft in informant's house. Subsequently, during course of investigation, one co-accused was arrested.
Notice returnable on. We'll give you the same date in July, the 15th.
My lords, if
15th
it
July.
can be in the partial working days. Subject to
One
lordship.
the partial working days. 22nd June. 22nd June?
Grateful.
Well, so we shall be affected by all means.
May it please your Lordship. Lord, this I'm seeking regular bail, Lord. I was only 18
On
years.
your shoes, they find
Yes, Lord. I'll Lord, address all
DNA
those,
of the
those
victim.
points, Lord, I'll address. And Lord, I was only 18 years, 3 months. Lord, there are a lot of people. Crowd. I'm grateful.
That is the
Yes,
first
Lord.
thing.
Crowd.
There was a crowd there,
Yes, Lord.
Murder committed in the crowd.
Crowd, Lord.
Could fall on anybody.
Yes,
Could
Lord.
fall on-
but some blood-stained clothes were also seized from.
Close my shoe, they say that.
On the
there was a
shoe,
spot.
they
On
said
the-
DNA, but blood-stained clothes also seized.
There was a spot of blood on the
No,
shoe.
not on the shoe. The clothes also, there was some blood.
Because that, it says it's a mixed DNA profile, Lord, not.
Okay, but then where did the blood come from?
But
Only the
we were
murdered
there.
person. Only the murdered person.
No, no. We were there, Lord. There were a lot of.
Very well. Issue notice.
My bad.
May condone, issue notice. This can wait till July?
Yes, Lord. I was.
15 July.
I'm grateful.
With some cultural program.
Yes, Lord. There was a cultural program going on, Lord, and I'm grateful.
Item 16, I am appearing on behalf of.
Lord, I am in item 16.
Yes.
The petitioner is in custody for about, my lord, more than eight months now. Was arrested on 5th September 2025. Until that, there is a disclosure statement, FIR delay, my lord, 1.5 years. The first call was made, my lord, on 7/2/2024. I was not the beneficiary, my lord, at any point of time. My account number is not there. My mobile number is not there, my lord.
No, but your call center, you are an employee of a call center.
Earlier, my lord, earlier 30 employees were arrested, my lord. I was a my lord, person who used to work at the instance of my lord.
Chat and all this. Maybe not even what they have against.
Lordship,
Issue notice returnable on.
one caveat, Your Lordship.
Can it
You're
be
for?
my lord, may I request in June, my
I'm for
lord?
the informant, Your Lordship.
You're for the complainant,
I'm for the
not made a party here. Were you heard by the High Court?
Yes, Your Lordship. I was there, Your Lordship.
What do you have
I
to
just-
say?
I just want to point out one thing. Police has recovered 17 lakh rupees in this matter, Your Lordship.
Not from him though. Some bank accounts were frozen,
Some bank account was frozen.
not his account. But they know where the money went, so those accounts have been frozen. 17 lakh is there.
But that particular amount was recovered in relation to this investigation.
Very well, but what is there to implicate him? Except for that, what's his name? That, that KK, Kalyanshu Kumar Bharadwaj names this man. And then they say there's some WhatsApp chat or something like that.
Correct, my lord, correct.
He did not file that particular statement of his disclosure statement.
Who's Bharadwaj?
This particular person.
What is his disclosure?
His disclosure statement is that he explained the modus operandi of the.
No, recoveries. Any recoveries made?
Not recovery.
Then without that confession by itself is of no use at all. So what is there against him though? Nothing else.
Will file.
So why do you fall into all such mobile calls? Mainly gullibility of people.
You actually had a insurance policy which was maturing.
The problem in these matters, Lordship, is that it's very difficult to have all these.
Everybody wants easy money. Somebody calls you and says that you are getting 1 crore, give me 10 lakhs, immediately you.
I bought on Lordship, but in this case, the facts is different. There's a policy.
Anyhow, we'll include. What is the name? Give the name of the complainant, please. We're informed that the complainant was heard by the High Court, but was not made a party to the proceedings. However, as the complainant has filed a caveat before this court, we are of the opinion that he would be entitled to be heard. It's accordingly implicated so motu as respondent number 2. Issue notice returnable on.
Lord, I am for the state.
No,
No, I am already.
someone is there for the state.
Lord, I am for the state.
Issue notice returnable on 15 July. Acts service of notice is waived insofar as the respondent is concerned as Mr. So-and-so and Mr. So-and-so. Mr. Ankit Goel for the state and Mr.
Shashank Singh.
Give your name and the name of the complainant, give the full details. Before you leave though, write it on a piece of paper and give, otherwise the whole exercise is doomed.
I'm good.
15 July.
Please.
Oblige, my lord.
Yes.
My lord, in this case, praying for granting the regular bail to the petitioner in a case of 302. My lord, in this case, petitioner is a lady. And my lord, in this case, what happened? That the incident that was on 19th of January 2024.
Postmortem examination report that you filed is obviously not complete. Page 90.
Please, my lord, page number 19.
It doesn't say anything about the body, what exactly was found. Nothing is mentioned.
My lord,
The allegation is that the father-in-law sexually assaulted her before she died.
Exactly, my lord. As
Is
per
there
the
any evidence of it? The body would have disclosed the
only
the body would have
only one line, page number 19. The cause of death in this case is asphyxia
No, but
as a
the-
result of smoothing, my lord.
only the cause of death is mentioned without mentioning the result of the
Sexually
total examination.
result, there is nothing at all in the
How is that
postmortem report.
possible?
My
What
lord.
kind of opinion?
My lord, my respectful submission that such lady, she's having no antecedent at all, and the custody is around 2 years, 4 months, my lord.
You are supposed to have held her hands while your husband sexually assaulted her.
My lords, I am appealing for this
And then the husband smothers her with a pillow.
Please, my lord. Well, as per the allegation, they are saying, and the allegation qua the present petitioner that she caught her legs basically at that moment.
I don't think.
No eyewitnesses, nothing at all. It's only the case of circumstantial evidence, my lord.
Good.
My lords,
There's a question of you're saying that I have ill health, I have breast cancer. That's hardly a
Please,
reason to let you
My
out.
lord, initially, the Honorable High Court, Annexure P5, my lord, granted interim for 8
Interim
weeks.
bail for 8 weeks you were granted. So
Granted, my lord, subsequently I am surrendered within the time work, my lord. I am saying that
May have
she is a
surrendered,
lady.
but hardly a case for grant of bail. The young girl
My lord,
lost her life.
My lord, at this stage, my lord, total 20, my
Husband
lord,
is in the
witnesses.
US and she comes for a wedding and the mother-in-law and father-in-law do this.
My lord, as per the allegation, but there's a delay of, my lord, 8 days for gestation of FIR, my lord. The date of incident, that was on 19th, my lord. And my lord, 27th, there's a delay of 8 weeks, my
With the
lord.
impugned
8 days,
judgment
my lord.
passed by the High Court, especially petitions
I have to
accordingly
verify from the ST, my lord.
passed by the High Court at this stage.
When did you file it?
I am for the state, my
I
lords.
filed it 29, my lord.
Sorry? I didn't hear. Who spoke up now? 17 R1, you want your name to be recorded? Mention his name, Karan Sharma. It's already there. You get it on advance notice also.
Obliged, my lord, grateful, my lord.
18. 18.
Your Lordships, I'm seeking a pass over Your Lordships, item 18.
Responded.
19. Judgment is sought by the Learned Counsel for the petitioner on
My lord, have it on the opening of the court.
medical grounds. The matter is accordingly adjourned. There's a delay of 52 days in the filing, 170 days in refiling. And now you want a quick date to be fixed. After seeking an adjournment.
Not a quick date, my lord, just after vacation, whatever dates you lord.
Yes,
As soon as it could be.
14th August.
And April, but
My lords, in item 20, I had circulated a letter, my lords, for adjournment.
20 no letters been circulated.
My lords, today only I got an email that the letter has been rejected. I had mentioned personal difficulty of the council yesterday.
Adjournment is sought by the Learned Counsel for someone is
My lord, I'm
You're on
the
period.
payment for R2, R3, R4.
Very
Just
well.
after
Learned
summer
Counsel
vacation, my
wants-
lord.
Learned Counsel wants time, so we'll adjourn it.
Okay, my lord. Our list after vacation, my lord.
Yes, it'll be after vacation only.
Okay, my lord.
Learned Counsel for the petitioner seeks petitioners. Petition adjournment on personal grounds. The matter is accordingly adjourned. List on 27 July.
I'm so
Grateful, my lord.
31. Sorry,
May I-
21.
May I please?
Was present in court. The order records it.
Yes,
There is
my
a
lord.
question of his blaming the council now.
My lord, earlier also.
The learned judge has taken
filed.
the learned judges have taken the trouble to note that Mr. Narayan Das Gelmal Masan, appellant, is present in court.
No, my lord, he was not present in the court, my lord.
It is there, page 2. What are you saying? Page 2, top. Advocate Shivaji Yadav for the appellant, Mr. Narayan Das Gelman Masan Gelman.
My lord, that is the grievance. I was not present.
German. So there's no question of his now saying that I didn't know what was happening. He was present
He's
in court.
82
His advocate asked for permission to
He is
withdraw.
82-year-old person, a truthful person, my lord. He say he was not.
You're given liberty to challenge that order. Whatever your advocate was advising you, you follow up on that. Delay condoned, however, we find no good ground and reason to interfere with the
Delay condoned, my lord.
judgment and order dated 17/3/2025 passed by the High Court. The special petitions accordingly dismissed.
Grateful.
22.
May I please, my lords? My lords, this is an order, my lords, where, my lords, the section 34 order was quite balanced, my lords, and no interference was called for in 37 for mainly for two reasons, my lords. While they claim 29 lakhs, my lords, then 59 lakhs is given to them. The other point is, my lords, that the arbitrator observes that the termination was not given by the competent person. The arbitrator completely missed the letter dated 1/6/2012, my lords, which is Annexure P23, which was issued by the superintending engineer, my lords. So these were the glaring things, my lords, in this which warranted an interference under 34. However, my lords, while
On which ground under 34?
my lords, the ground under 34, my lords, may I read the portion at page 877, my lords, of the section 34 order?
Court mention as to why it is interfering under which ground?
Yes, my lords. So, yeah, I'm so obliged, my lords. It is at page 877. It's in volume 2, annexure P48, my lords.
877.
877.
Yes, 877.
Yes, my lords. My lords has it, then I'll read.
870.
There are 2 volumes, my lords. It's in volume 2.
Yes.
So, my lords may kindly see from the second para. On perusal of the said letter dated 1/6/2012, it appears to this court that it is none but the superintending engineer PWD who invoked the clause 2 of the agreement asking the respondent firm to pay compensation to the tune of 42,33,000 as per recommendation of the executive interior. This court thus holds that the principle of law as enunciated in the case of Sassyong Engineering can be squarely applied in this case, since the arbitrator, while allowing the claim number 3 of the respondent firm, committed a patent illegality by ignoring the letter number so-and-so dated 1/6/2012 as written by the superintending engineer PWD, and thus the decision of the arbitrator in this regard can be held to be perverse and liable to be set aside basically on the ground of patent illegality. So this court holds that the award as passed by the arbitrator while allowing claim number 3 of the respondent firm on account of loss of profit is liable to be set aside under section 34 subclause 2A of the same act. And the next paragraph, admittedly, while allowing claim number 3 of the respondent firm on account of loss in profit, arbitrator awarded a sum of rupees 59,51,032, though before the learned arbitrator, the respondent firm herein has claimed 29,76,504. So, Manoj, these are the main 2 grounds. This 1/6 letter was completely lost
This
sight
is nothing other than a merits-based evaluation.
my lords, but then therefore, my
Where is
lords,
the question?
my lords, but in 37, where was the question of interference? That's my humble submission, my lords. In 37, when the 34 order,
Merits-based evaluation that the 34 court undertook. 588.
sorry, my lords, I didn't get that question.
Once that is there, the 37 court is perfectly justified claim.
My lords, in fact, my lords, in my humble submission, my lords, that the 37 court has completely reappreciated the evidence, has dealt with it in a manner as if the 37 court was the arbitrator, and my lords, order has been passed. Whereas, in my humble submission, the 37 court is to look into any error in the 34 judgment, because my lords, Gayatri
You
Balaswamy,
are not correct there. Gayatri Balaswamy, we have held that the 37 court's power is coterminous with the 34 court's power.
But my lords have
Therefore,
also
it's
held
not
that
just-
if
it's not
34
just
is
that,
narrow, it
the
is narrow.
37 court is only looking at the correctness of the 34 order.
My
It
lords, so
exercises
therefore,
all the powers that the 34 court has.
my lords, I am so grateful and
Therefore,
obliged, my lords. So
can't say that the
therefore,
scope of 37 is limited when compared to 34 court's power.
my
That is
lords,
not correct.
my lords, I bow down, my lords, but kindly see the 34 court clearly goes into this fact
No,
that
what you have shown us is clearly a merits-based evaluation.
therefore, my lords, court the 37
Nothing
court
more.
reappreciate the merits. That's my humble submission, my
No,
lords.
no,
This
it
was
has
the-
not. It has restored the award, saying that the 34 court ought not to have done this.
My lords, but this perversity, my lords, somebody claiming 29 lakhs, my lords, and then 59 lakhs is being given.
How is it a perverse order?
Shook.
Yes, how do you say that?
Miss, much more than that. Where's the question? Delay condoned, however, we find no good ground and reason to interfere with the impugned judgment passed by the High Court, especially petitions accordingly dismissed.
Public.
My lords.
Your lordship's limala physically appearing.
How did you manage to come, Mr. Reddy?
There was no prohibition. I was waiting for this thing only, but after seeing that advocates are there inside, I.
No, but how did you manage to come? I'm told that most of them have come by public transport. I think the senior advocates have been requested not to bring their cars. Oh, you came by car? You're in breach of the.
I came directly from Hyderabad.
Hyderabad, you came directly. So you're not aware of this. You're not aware of this new circular that was floated. I think they've consulted the Supreme Court Bar Association also about it.
That's probably
After seeing the video,
Be hopeful that your car still remains, that they don't chase it away.
It is outside only.
It's outside only, very well. So you might be still safe. Yes.
The petitioner family was enjoying this land for the 3 generations. The earliest gift deed was of 1345, that is 1935 million. And the corporation itself accorded the number. Permission was accorded in 2022. First show cause notice in 23. On the one hand, they paid compensation for on the one hand, compensation was paid for road winding, my lord, and now they say they road after 2 years after
the second appeal. It was the first appeal.
EMS.
Second appeal, my lords.
Who was the first authority?
Who
was the first authority?
First authority was the court, my lord. First authority is commissioner.
Second appeal against the municipal.
So an appeal lies under this thing. Appellate remedy was. Miscellaneous second appeal was to the High Court. That is it. Chief Judge Civil Small Causes Court, my lord.
Given the liberty to approach the GHMC again. You're given liberty to approach the GHMC again.
Once again. But construction is complete, my lord. Construction, at one point of time they said you have did not leave the.
Because in the second appeal you did not disclose the writ petitions, perhaps.
Yes.
Writ petitions were not disclosed as the finding.
At that time. But I am told that after recently one writ petition was disposed of, leaving it open to me to approach the complaint third by way of appeal. 2 writ petitions are pending.
So you will have to approach the GHMC now because they say it's a public lane that has been encroached.
So, your Lashima can see whether he has been simply the impugned order at page number 40, not a word is said. He, page 46, may I read, my lord, page 46. He notes my contention, not a word is said about it. Simply, page 46, my lord.
46?
46.
Yes.
Second paragraph. Accordingly, show cause notice under section so-and-so has been issued to you, white 9 cited, upon which you submitted reply to the notice by reference 10 cited, wherein you stated that you are the owner of the premises bearing number so-and-so, AC Guards Hyderabad, dated so-and-so, SRO Golconda. You have also stated originally the property bearing number so-and-so.
So, but the question is whether you are now encroaching onto a public lane, whether you are making unauthorized constructions.
No.
How will we decide those aspects?
Yes. Here, they accorded permission after you may invite your lordship attention to page 40, my lord. It is not
you got the building permission, no doubt.
Yes, my lord.
After that, it's been cancelled now.
Cancelled after construction is over.
After the construction, but according to them, you were also making some unauthorized second floor construction.
That,
There is also misrepresentation in the building permit application.
No.
Is the ground on which it has been cancelled.
first, my lord, they issued a notice, show cause notice in 23 saying that you did not leave the setbacks. Page 39 is first notice, my lord. First notice, they said you did not leave the setbacks. The explanation is, we said not only setbacks, we left much more. Only thing they were taking exception to a pillar raised at after the first floor. We said it is only for the purpose of garden.
Authorized construction part of it also still remains?
Yeah, that they issued a notice on page 36.
So this is for the council on the record.
Page 36 is the notice. I submit explanation, the matter ended there. Page 36 is the notice, my lord, alleging that I have not left the setbacks. That was page 36. Explanation was submitted page 37 and they left the matter at that. After 1 year, on the basis of a letter said to have been addressed by the Tahsildar, he reopened the issue. And we said everything, and without uttering a word, he simply cancelled. And it is another case where for the first time it is coming. Earlier there was a page 37, I submit representation.
A function hall there and you are
No,
alleged to have...
Functional is third respondent. He is the person behind all these things. Functional seems to have been sealed on account of some violation. Now he is after me. Third respondent.
No, but the allegation against you is that you encroached upon a public lane.
First, my land in 2023, they issued a notice saying that you did not leave setbacks. That setback part of it, 2011-23, my lord, page 36. With my explanation, they kept quiet. 1 year thereafter, the third respondent person.
Public interest litigation pending.
Pardon me.
What is this public interest?
Public interest litigation is pending is what has
Public
been
interest litigation is saying that
with regard to the encroachment of the pathway.
in the generally that road part of it was being encroached, but the direction was issued directing to the.
No, but the finding on fact is that you have also encroached on the lane.
That was never the case.
It may be a case of the pot calling the kettle black, but both of you are black though.
No. In my case,
You guys are party in the, were you a party in the public interest litigation?
No. I am not.
You're not a party to.
No. And here, my land, in the explanation I said, front part of my property was acquired for the road widening and compensation was paid. The question of my encroaching does not arise. In my explanation, they paid compensation to me for widening.
Correct. Issue notice, turnable loan.
Once they paid compensation.
24th July. Any threat of demolition now? Threat of demolition is there.
Yes, they thought demolition.
Status quo obtaining as on today shall be maintained with regard to the building in question.
Grateful, my lord. Extremely sorry if I have violated anything.
In fact, well, all of us have our individual opinions, but anyhow, if it helps, it helps. If it doesn't help, this is.
I was maintaining restraint. I was waiting outside. In the video, I saw that advocate friends were there. Now, why not I have the benefit of?
No, there are some. They told us that most of them got here by public transport. Because
much obliged.
My lord, senior is appearing through VC.
Yes.
I appear for the department. It is a claim of the respondents which is logically faulty and that they've not been able to discharge the owners of proof. They claim that they received these gold bars from the 2005
But then the system,
of the grandmother.
that appeal was dismissed by the High Court on monetary limit, litigation policy. What
No, but that is under recall. We have
Less
filed-
than 1 crore.
Less than 1 crore.
Your recall is still pending.
The recall is still pending.
That will have to be considered. We can't be considering it.
If we
Litigation policy.
You need to.
infractions.
It was dismissed on 18 March 24 till now. If you don't get it recalled, obviously you have to return the gold then.
Just about 3 months from the time the order was pronounced.
Sorry?
We filed it within 3 months from the time the order was
They
pronounced.
should have asked for it.
But after that, you've not pursued your recall to get the order recalled.
Yes, pursuing the case before the Honorable High Court. is that-
As matters stand, the finding is that this gold is not smuggled into the country.
And they did not
inherited it.
And they did
Yes,
not.
Your Lordship. But however, if one looks at it,
Where have you submitted before the High Court that you have filed a recall application? You have not said there is nothing said.
It doesn't record it.
Then they'll have to pursue it.
Para number 3, para number 4.
Oh, yes. Learned appear and other responses.
Has been filed.
Review, not a review.
Doing it consistently before the High Court.
How can a review be maintained because
No, but
litigation
Lordship,
See, it is the litigation policy of the government. There is no question of a review.
But they cannot be seen into SSC wise because these are consolidated. The value has to be seen in a consolidated way because the SSCs are all related. So we cannot
No, see, the litigation policy does not say about the consolidated value of gold which is smuggled in all over the country.
You get it from the bank locker. It is not as if it's seized while he's coming into the country or something like that.
These are
From a bank locker.
No, but these are foreign gold bars which were recovered from the locker, which were not declared.
If he says I inherited it,
My lords, may just see one order of the Slst. I'm sorry, I'm appearing for the respondent, my lords. Please see order of Slst 165 to 184. This is inherited by my will. There was a will. Please see page 165 to 184.
165. Where is the reference to the
bill?
Yes.
Let me have first.
Wait, there's a reference. Just 1 second, Uday. There's a reference to the will at page 170, my lords.
Yes.
Yes, may I read it, my lord? It was further submitted that the sell bid was made on so-and-so and the recovered gold was owned by grandmother so-and-so and left with her by It was admitted that Srimati had that the will in question not given details so the said will was executed in the year so-and-so. The officers further sought information from the officer. It was sought, the officer says 180. Then finally at page 181, after going all three, going everything they said, at page 181, yes, 4 lines from that bottom. The said will which was executed was duly notarized and stand probated also, my lords.
Oh, Lordship,
181, 5 lines from the bottom, my lords.
And what exactly does the will say? Do you have a copy of the will here?
No, my lord, this is, I am appearing on a caveat, my lords, today.
Well, I see. It's not fine.
Let me complete.
So today, my lords, I have 2 submissions. They disposed of, there was an order in 2019 in my favor. Then a High Court order, my lords, in 24. I don't know when they disposed of my gold. And today they are saying,
Lordship, there are 2 aspects which lordships have to consider in this case. First, these gold bars were of those companies.
You are only on whether it is to be returned or not.
Business
At the moment, Mr. Khanna, you have nothing because the finding which has attained finality as on date is that this gold was not smuggled, it was inherited. Once it is inherited gold which you have taken away, you either have to return it. If you don't have it, then you have to return the value of the gold.
Value of the gold, yes.
3.5 kgs.
I would like to respond on 2 aspects here. First, the will is of 2005. The gold bars were of those companies which started the operation post 2006 and 2008. That is the first aspect. The second aspect.
Does the gold bar have any stamp on it?
They have a stamp of the company which started the operation in
Does
2000.
it bear the year in which the gold bar was manufactured?
No.
There's no such.
No finding to that effect.
You can't say that the company has come into existence then.
The other thing which I have to point out is that there's a circular which says the refund could not have been made on the market value. It has to be on the basis of the average market price on the day you hand over the goods.
No, you can't take away his gold.
Yes.
You say that I have already sold it. I'll give you the value as on 2018 now.
Yes.
The law doesn't
17 or
state that
18,
you have to
whatever it
give
is.
the market price.
Sorry, we
Yes,
find
but-
no good ground and reason to interfere with.
So grateful, my lords.
Passed by the High Court, especially petitions accordingly dismissed.
So grateful, my lords.
My lords, I am the bona fide auction purchaser in this matter. Auction was conducted by the district revenue authorities, my lords.
You filed a vacate stay, follow up on that, please.
My lords, I'm only request, my lords, is that it may be taken up in a time-bound manner within 6 months.
No, we are not here to arrange the boards of the High Courts, please.
My lords, it's
For the
pending.
Chief Justice of that court, if you have a complaint.
My lords,
to
humble
make,
request. It's pending for final
What is that?
disposal since last 2 years. In May 2024, it was
you
resolved.
can show him Article 226.
That I may, my lords, but my humble request.
3, subsection 3, and tell him that this is there in the Constitution, but not being followed.
My lords may set any limit, my lords, at least 6 months.
We can't fix a time frame for this. Delay condoned, however, we find no grounds to.
My lords may encourage
The order
them.
passed by the High Court. It is for the petitioner to take necessary measures for the listing of his vacate stay petition. In the event the main writ petition is not being heard, he is at liberty to make a mention before the Honorable the Chief Justice of the High Court in that regard, especially if petition is according. Yes. Your liberty to make a mention, just make a mention and see what comes out.
Grateful, man.
Yes.
Whether
Item 26,
I'm seeking a transfer in this matter, my lord. I've been led by Mr. Siddharth, the senior advocate, who's on this.
Pass over.
Because item 27, my lord, the respondent 31 has been added as a party defendant. There's a suit declaration or cancellation of a document, my lord, where she was not even a
Liberty
party.
is given to you to disprove her claim that she is the daughter of the first wife.
No, that's a separate claim, my lord, which she can approach the court, my lords. This is a suit for cancellation of document, my lord, which she was not even party to.
No, but that property is the property of the deceased husband, is it not? She obviously has an interest in his property.
She's claiming that she's the daughter of the second wife. Millers, there's an affidavit filed by the deceased saying that he has just one wife and the children are the petitioners.
We don't know. That's the reason why liberty is given to you to disprove her claim that she is the daughter.
Miller, let her file a separate claim to that effect. Miller, in a suit for cancellation of documents, she's coming here.
If that property is his property, then obviously she has a right. We find no good ground.
That could be a parallel proceeding that she can.
An order passed by the High Court, especially if petition is accordingly dismissed.
I'm grateful.
Yes.
May I please, your lordship? Please, your lordship.
Yes.
The impugn order dismisses my application filed under Order 41 Rule 5 of CPC, and the interim stay earlier granted by the Honorable High Court is vacated. The first ground before your lordship is that the Honorable High Court has in effect decided and upholded the fact finding given by the learned trial court without any cogent reasons. So, my lords, may kindly come to page number 7 of the impugn order. It's para number 14.
Para number 14 is what we're looking at.
Please, Your Lordship, at page number 7 of the impugned order. Well, it's upon a careful perusal of the material available on record and the impugned judgment dated 17/5/2025, this court finds that a finding of fact.
One moment.
Please. May I continue, Your Lordship?
Yes. Will issue notice, counsel.
Please, my lord, my delay be condoned and my lords, yes, tomorrow there is an execution listed against the impugned judgment and decree. My lords, that be stayed. Because in that
Earlier interim order was of which date?
my lords, the impugned
23rd
judgment.
July
and-
2025. Very good.
Please, Your
Delay
Lordship.
condoned, issue notice, returnable on.
My lords, may I please submit one thing, my lords? My lords, execution proceedings is listed tomorrow before the learned additional
17th
district and
August.
session judge. That be
Shall
stayed,
be
my lords,
effected
because
by all modes, including Dasti. Earlier interim order dated 23/7/2025 passed by the High Court shall stand restored and shall continue till the next hearing. That should do.
I am so grateful. Deeply obliged.
President 30, I appeal to the petition.
Yes.
Now here we are requesting notice for the reason that there's an interesting question of law. It has to deal with, I might just indicate,
Coming to us at every stage, but now the main case is decided.
yes, and that's why there is this issue under Article 243X and 243ZF of the Constitution. Your Lordship takes that up.
Are they extracted here? No.
They are extracted, well, not ZF, but 243X is, I think it's quite used to have a book, but if you, anyway, I can take your Lordship to the review.
Which page is it,
Please
Mr.
go to page 8.
Page?
One of the things, 8.
8.
8 as in the 7, 8.
Is it? Oh.
Yeah.
Yes.
Now, your Lordships may see 243X towards the foot of that page. In para 8, so where I place it. Power to impose taxes by and funds of the municipalities. The legislature of a state may by law authorize a municipality to levy, collect and appropriate such taxes, duties, tolls and fees in accordance with such procedure and subject to such limits. So I am emphasizing the expression subject to such limits. Now, what is that? There is another statutory provision, a provision in the Constitution of Article 243ZF, which gave the state governments 1 year to bring their local laws and municipal corporation laws, etc., consistent with the provisions which were introduced in the 74th Amendment. Now, what has happened in our case, your Lordships, will just go, will directly go, and why we raise this challenge. Please go to page 112, 113.
Yes.
Now, at 112, you will find there is a quoted portion in the communication.
Yes.
So the communication to the cooperator, this is what we had, and this is the resolution which came to be passed. Now you'll find a reference to section 479(2) on the 5th line at the foot of page 112. You know about that?
Yes.
479(2). Now, this is an old provision of the Bombay Municipal Corporation Act dating back to 1888, although it has been subjected to some small modifications, etc., which are not material for our purposes. I'll take you to that provision for a moment. But please see what was challenged. So I'll just place this. Municipal corporation, by making partial changes in the earlier orders passed by resolution number so and so. Well, this is resolution 999 dated 11th December 2009. As proposed to making revision in advertisement fee as known in Carter A and Carter B in Group Kerr and Kerr, and in column 5A in Group G, as shown in the appendix Annex 2 in the first in the fee schedule for advertisement license issued under sections 328 and 328A of the Municipal Corporation Act 1888 by making a hike to the extent of a flat 80%. So first, they hike it 80% the existing license fee. Then please see what happens of the prevailing rate for a period of up to 1 year after the sanction of the Municipal Corporation, and to the extent of 10% per annum every year following thereafter, and by converting the same to the nearest town figure. So they introduce a law which is open-ended, which increases the license fee without any limit, 10% year on year. And as we have explained in our petition, it is compounded. The interest, the effect is compounded. So our legal point is that assuming the legislature has, we assume, and it's correct, that the legislature has the power to grant, to confer on the municipal corporation the rights to issue, to levy fees, fair enough, but the legislature has to prescribe limits. What are the maximum? What is the minimum? How often can it be done? Now, there is no such provision at all in the parent statute, and you will find that.
479(2) says?
Yes, please have a look. That is also extracted. You'll also find it in page 7. 7. That's part of the interview judgment.
Yes.
Your Lordship has 479 towards the footnote of page 7. So I'll just place that. Licenses and written permissions to specify conditions, etc., on which they are granted. Now I'll take you to subclause 2. Fees to be chargeable. For every such license or written permission, a fee may be charged at such rate as shall from time to time be fixed by the Commissioner with the sanction of the corporation. Our point over here is that this is, of course, an old statute, as I indicated to your lordships. At that time, there may not have been a requirement for limits. So both under the general law, which is that, look, you can have a delegation of taxing powers, provided there are limits. So the delegate must know what is the maximum, what is the minimum, etc., which can be prescribed, how often can they revise it, etc. That aspect is completely missing in our respectful submission, insofar as section 479 is concerned, specifically 479. So they didn't bring it to comport with the mandate which is brought in pursuant to the 74th Constitutional Amendment. So that's my first and primary point. This is an issue, according to us, which requires consideration. You can't have an open-ended system. The second is the impact and the effect. Please look at this. 80% increase in 1 year, and thereafter 10% year upon year upon year upon year, without any limit, without any cap. And so we are facing tremendous adverse consequences as a result of
one moment, Mr. Dev.
Untraveled power.
We will issue notice.
I'm grateful. Manoj, I realize that I can't ask for a stay immediately, but I would request notice of stay, because at least the municipal corporation will come forward and say, are they going to keep increasing this 10% year on year? Because at least for the future, there may be some guidance which is to be provided at the interim stage.
Let them come forward, thereafter we'll see.
All right. So then your lordship will just issue notice and take custody.
Notice. Issue notice on the special leave petition as well as on the prayer for interim relief.
I'm grateful.
Turnable on 15th, 15th July.
I'm grateful. May I request Dusty?
Service shall be affected by all modes, including this. Thirty-one.
31, Lord, please, Your Lordship, Lord.
Yes.
Lord, I'll raise only one point, my Lord, which I think, my Lord, would appeal to Your Lordships. Please have a, my Lord, this was a contract given to the respondent Newton Engineering on a condition which, according to us, is a mandatory condition that they would have one technical partner with a technical know-how without whom they cannot discharge their functions. Lord, please come to page page 146 first.
146. Yes.
146, my Lord.
Yes.
Para 117. My Lord, Your Lordship gets, my Lord, 146, 117. As regards the role of UEM, my Lord, that is
The technical partner. Yes. The
the joint, my Lord, constituent of the joint JV.
Yes.
Both sides have made detailed submission, but in our view, it is not necessary to set them out. Admittedly, without the MOU dated so and so with UEM, the claimants did not qualify for being considered under the subject tender. Admittedly, the claimant was awarded the subject contract based on the credentials of its technical collaborator, Messrs. UEM India Limited, New Delhi. This is admitted by claimant's witness in answer to question number so and so. I'm not reading the answer, my Lord. It's an admitted position. Now, please oblige me by coming to page 205.
Show us your agreement itself where you say that is there such a condition in the agreement? Because your agreement is only with Newton.
Yes, my Lord. Yes. My Lord, for that, my Lord, if Your Lordship can come to page 148.
148.
Para 124.
Yes.
My Lord, that would be an answer, but I must give it correctly.
Yes.
It must be mentioned at this state that the
1 moment. 148. Page 148.
148, para 124. My apologies.
Yes. Yes.
Because contract does not. My Lord, my answer is contract does not stipulate. My answer has to be correct to Your Lordships. But the very fact that I wanted a person with another person with technical expertise, my Lord, means that it is mandatory. You cannot do it on your own. Please have a look at 124. Just to answer Your Lordship's question, it may go against me. It must be mentioned at this stage that the contract does not contain any provision for signature of EUM on all documents, and the contract only makes the claimant responsible for execution. Please now see. However, the respondent insisted on involvement of UEM in the fields whereunder the MOU, UEM had the primary role. MOU between UEM and, my Lord, the Newton.
No, but insisted by way of what? Correspondence?
Yes, my Lord, by me. I am the respondent before the tribunal. I am reading, my Lord, arbitral tribunal's award.
No, you insisted is what is written here.
Yes.
How did you insist? Did you
By
write
way
to
of
them?
letters, my Lord, communication.
By way of letters, you said.
Yes, my Lord. I'll read further. It may be that respondents were not absolutely correct in insisting that UEM sign all documents, but the fact remains that claimant had to satisfy respondent that UEM was involved and had approved what was submitted. In this context, my Lord, please read 205. This is again, my Lord, not a fact which is contested or in dispute or held against me. Para 181.
Yes.
Your Lordships are, my Lord, with me on page 205.
205.
My Lord Justice Chandran.
Yes. Yes.
At the bottom, my Lord, page 205, page para 181. It has been very seriously submitted. My Lord, I can say it's not disputed by the other side. That claimant failed in its duty to furnish drawings. It was submitted that claimants were to furnish 399 drawings before removal of sludge. It was submitted that claimant supplied only 29 drawings. On the other hand, on behalf of the claimant, it is submitted that all drawings required to be submitted were submitted, but the respondent refused to consider them as most of them were not signed by UEM. But this is where the UEM's role comes. We wanted them to technically take the responsibility of signing the drawings, and out of 399, only 29 are signed by them.
But you do not include this as a condition in your contract itself. It's only by way of correspondence.
Your Lordships are right. That's a correct. Correct answer is yes, I did not. But the contract between, my Lord, the EUM and Newton did provide that they would be taking care of the technicalities on the site.
But that was between them. So far as you are concerned, you never made it a condition precedent.
Based upon which we granted the contract. So your lordships may kindly see page 147.
Yes.
Para 119.
Both courts have held against you.
My lord, I am, my lord.
24 as well as
That's, my lord. But that may be one of the factors. My lord,
going into a merits-based evaluation at this.
My lord, the difficulty is this. Why, in my submission, your lordships may consider this.
Contract doesn't even stipulate participation by you.
Would your lordships, my lord, allow me to see, my lord,
Even what you read out at page 146,
yes, my lord.
that answer ends by saying UEM was our subcontractor, not responsible to the ONGC.
My lord, the difficulty is when, my lord, we insist that you will come only if you will be qualified, only if your technical partner is qualified. My lord,
I was more mindful when the contract was drawn up, though.
My lord, would your lordship see, my lord, 146? 146, my lord, I did not read it, but let me read it. 146, page 146.
Yes. Only
My lord, the question answer. My lord, this is right. Your lordship's read, my lord, the first part.
Yes.
But the deposition, your lordship's, my lord, I did not take your lordship's through. Para 31, your lordship's, my lord, in para 117. It's a quotation.
Yes, you were qualified on the basis of UEM's technology.
Yes, is it correct that claimant did not possess?
It's not as if UEM was not involved. According to you, UEM's signatures were not there on all the documents.
No, my lord, it was not involved. My lord, that's our case. My lord, illustrate, we have said.
That's a purely factual finding. Where is the question?
My lord,
Mr.
one
Diwan,
last.
you are on caveat.
Yes, you're
My lord, one.
Yes.
My lord,
What do you have to
119.
say? Let us see
My
whether
lord,
Mr.
119.
Diwan
So
has
only a
any
minute,
more-
my lord.
Let us see whether Mr. Diwan has any more nails for your coffin.
My lord, only one, my lord, better, my lord, lead in the coffin.
One moment.
My lord, I am sure one para will help me, my lord.
Which
Your lordships
paragraph?
may kindly allow me page 147,
Yes.
para 119. This would answer my lord's question also.
Yes.
The lordships have page 147, 119.
No, but this
At
is
the
again just
kickoff-
some meeting that you had.
My lord, kickoff meeting is always, my lord, the first meeting.
Very well. Let us see, where did you take the specific stand that UEM was not involved at all? It wasn't just a question of not signing, but not involved at all. Did you take that stand at all?
UEM was involved in this common ground.
My lord, it was involved, my lord, on a periphery, maybe.
Sorry?
But it may have been involved in a periphery, my lord, as I have pointed out.
How did you take that contention specifically?
My lord, it's a.
As far as I remember, there's nothing there.
My lord, can
What
I
do you have to
find
say,
out,
Mr.
my lord,
Diwan?
and let your lordships know?
Let us see what Mr. Diwan has to say.
Or,
Yes,
my lord,
Mr.
by
Diwan.
Friday, I'll answer this question, my lord.
No.
If there is any specific contention or
There
finding.
you would have definitely picked on it, Mr. Obviously, it's not there. Yes, Mr. Diwan.
No, because my points are quite simply that this was that they went in threadbare. It's a unanimous award, apart from the 34 and 37, which were also supported.
Your
It's a
voice is
three-member
not very
team.
clear, Mr. Diwan.
Am I audible now?
Yes. Little better. Yes.
Right. So, brother, I'm sorry about that. The point I'm making is that it's a unanimous arbitral award. All three members have concurred. Now, what was the award essentially? Please just consider this. Number one, the arbitral tribunal found that the termination was wrongful. Now, because the termination was wrongful, the bank guarantee which they had invoked was obviously restituted. That was one part of it. The second part of it was that there was some unpaid bill for some work which was actually done. So that was the second limb of the arbitral award. And the third part of it was that there was a loss of profit element, which they also recognized because the termination was wrongful on their part. Now, UEM, just to answer the question, was involved in the project. It had countersigned with regard to several drawings, etc., because there was an ETP which had to be expanded. All these are matters, Veloz, of fact finding, determination by an arbitral tribunal. And now with two courts for two levels of review, Veloz, I don't believe your losses under 136 would have much of a role in a case such as this. So I would respectfully submit that the matter deserves to be closed.
Yes.
Well, only last,
Not
only
against
last
Mr.
submission, my lord, if it appeals to your lordships. My lord, all public sector undertakings. My lord, all public, I'm sorry, my lords.
Yes. Continue.
My lord, all public sector undertakings, my lord, always, my lord, this is the model contract, that you will have one person who will be technically qualified, which will make you eligible, and their participation would be all throughout. But I understand, my lord, this broad-based proposition that all three members have agreed and 34 lost, 37 lost. But this is, my lord, the question which needs examination. My lord, when the very foundational...
Not when you don't take the trouble to draw up your contracts, making that clear. That is not there. Once the contract is silent on that, and it's a possible and a plausible view taken by the arbitral tribunal, where is the question of, and that too, it's a three-member arbitral tribunal. Sorry. We find, having heard the learned senior counsel of the parties, we find no grounds made out to interfere with the impugned judgment passed by the High Court, especially petitions accordingly dismissed.
Extremely grateful, Veloz.
Your Lordship's item 32.
We've dismissed the...
Yes, Your Lordships. However, Your Lordships, on the last date, Your Lordships had inquired whether we have filed any complaint, police complaint. We have, in fact, filed one. It was in June 2025 itself, prior to our issuing any reply. And from the very first date, we had been claiming that the checks had...
As specially petitions filed against the very same order have been dismissed by this court on 7/5/2026, we find no reason to take a different view, especially if petitions accordingly dismissed.
Please, Your Lordships.
May it please the court, Milords, I appear for the petitioner on item 33, Milords. Your Lordships have, pursuant to Priyanka Srivastava, subsequently in Vijayalakshmi held that the absence of an affidavit under 156(3) is a curable defect. Your Lordships have said an opportunity could be granted before passing any formal orders on the 156(3) application. That is point number one. That is held to be fatal against me. Point number two, which is more important, Milords, is that this is not just an application under 156(3), but it is an application under 156(3) read with 200. In a case of a complaint, private complaint under 200, Milords, with all due respect, there was no need for the affidavit to be there, stricto sensu, because pre-summoning evidence could have been taken, I could have been examined. Number two. Number three, Milords, what is essentially also put against me is that this is in entirety a civil dispute, Milords. Can I just impress upon your Lordship that this is not merely a civil dispute? There are two dates which are important, Milords. The accused A1, A2 in this case, Milords, are mother's son. The son has a partnership with me. The mother enters into an agreement to sell dated 6/9/2004, pursuant to which there is also a GPA dated 27/1/2005 for consideration, 16 lakhs consideration, page 5460. Acting upon the GPA, Milords, she also says at page 209 that she has received the entirety of the consideration that I have paid to her. On the basis of this, Milords, I go ahead, register this project with RERA. Would your Lordships kindly see that registration, Milords, 210. This is extremely crucial. This is extremely crucial. After having done this, Milords, this is a clear case of cheating.
One moment, Mr.
Sorry.
Page do you want us to look at?
Milords, 209 is the receipt which she says she has received the entirety of consideration. 210 is the declaration under RERA. Today, Milords,
This is a clear case of cheating. I have gone ahead, sold the flats, sold the units to other people based on this GPA, on the basis of this agreement to sell. My civil suit, Millards, the Sessions Court comes to a finding that I have initiated criminal proceedings after I initiated civil proceeding. That's an erroneous finding. Those also I will satisfy your lordship with the dates.
What happened to your suit now?
Suit is dismissed for default. My Order 9 Rule 9 application. My Order 9 Rule 9 application is pending. But
Still
that's
pending.
That Order 9 Rule 9 application is still pending, Millards. That's at page
2023, your suit was dismissed.
Yes, Millards. It was dismissed on 18th February 23, Millards. I have filed my Order 9 Rule 9 on 10th April 2023. That is pending.
And you're not pursuing that?
Millards, that's pending.
Pending? If you pursue it, it will come up. So if you don't take steps to pursue that, and you want to hold this Damocles sword over the next criminal proceedings, better way of.
This criminal proceeding, can I just? This criminal proceeding was initiated prior to the civil proceeding. Criminal proceeding is initiated on 24th October 25 by filing a complaint before the Sadar police station, page 99. The suit is filed.
October 2015, you filed the
criminal complaint. The suit comes only thereafter, Millards. So the
that is also in 2015 only.
That's right, 30th October 2015. But
at that stage, you decided better to pursue both. Thereafter, you made a choice and said, let go of the civil. Criminal is a better way of armed resistance.
Millards, kindly see this, Millards. She takes the entire consideration from me. She enters into a GPA with me. Because I've been non-suited on the question of Priyanka Srivastava, and then by a sidewind said that this is a
Delay could not. However, on facts, we are not inclined to interfere with the inclusion that's been passed by especially according to this piece.
Grateful.
Adjournment is sought by the learned counsel for the petitioner on the ground that settlement talks are in progress. Earlier interim order dated 15/1/2025 shall continue to operate till the next hearing.
I'm so blessed.
Not petitioner, appellant. Adjournment is sought by the learned counsel for the petitioner to who's appearing for the respondent in 35 state or private respondent. Respondent number 3. Respondent number 3 is.
My lords, I'm appearing on behalf of respondent number 3.
You've not filed a counter.
My lords, we have filed a counter. My lords, it's
Well, you seem to have served a copy on the other side. They've asked for time to file a rejoinder to it. But
My
the
lords.
office report records that you've not filed a counter.
My lords,
Well, you've only shared it with the other side and not with the court then.
no, my lords, it has been filed.
Have you looked at the office report, madam? This is dated 15th May. Paragraph 2 specifically records it is submitted that counsel for respondent number 3 has not filed a counter affidavit so far. Hence, no rejoinder affidavit has been filed.
My lords, maybe it is not.
File it,
My lords, I will just.
Office report dated 15/5/2026 records that respondent number 3 is yet to file a counter affidavit. However, it appears that a copy thereof has already been served upon the learned counsel for the petitioner, who filed a letter seeking time to file his rejoinder thereto.
My lords, may kindly not record
Matter is
that. My lords,
accordingly
please.
adjourned to enable the filing of a rejoinder. Learned counsel for respondent number 3 shall ensure that the counter affidavit is placed on record well before the next date of hearing.
Fine.
List on 19th August. Earlier interim order of status quo dated 25/8/2025 shall continue to operate in the next hearing.
Grateful, Your Lordships.
Millards, for the petitioner in 36 Millards.
Yes.
The petitioner is represented through the successful resolution applicant pursuant to IBC proceedings.
Yes.
In this case, the State Consumer Dispute Redressal Commission ignores the moratorium.
Let us see what the respondent has to say.
Millards.
Who is appearing for the respondent?
Time for this one.
Yes.
Moratorium order was passed on 9/8/2018.
And you filed your complaint before the SCDRC on 4th December 2018.
4 months later. Yes, my lord.
Therefore, that entire proceeding
Yes,
is
my lord.
hit
Yes,
by the moratorium.
my humble submission, my lord. I am a home buyer. They were
Have you at least filed a claim before the IRP or the RP, as the case may be?
No, my lord.
Then where you've dug your own grave.
They haven't filed a written reply before the state commission.
That's the question. You can't initiate
They were set
proceedings
before-
after the moratorium order. Where is the question?
But then I go remedialist, my lord.
You dug your own grave there.
But they take money, they don't inform the court also, they don't inform the state commission also.
Either way, your proceedings were hit by the moratorium order. There's no question of trying to save them also. It's completely against the law.
Article 142 of the Constitution.
No. Where's the question of our exercise? You are now for the successful resolution applicant.
Well,
Are you magnanimous enough to give them back their money or something like that?
my lords,
Because in some of the cases, the SRAs have been magnanimous enough to say that even if they did not file their claims, if they have paid more than 80%, will get back their money. How much have you paid?
12 no, 3 has been repaid and 9 more lakhs will be given.
No, how much have you paid?
12 lakhs.
You won't get an apartment now.
10%.
Apartment or villa, what is it?
Asking for the money.
it's a villa, they paid 10% according to their own admission. And out of 12 lakhs, 3 lakhs is already refunded to them.
Around 90
Or
lakhs.
three has been refunded, is it?
3 has been refunded to them and
12 lakhs you paid out of 90, out of which 3 has already been
because they
refunded.
were unable to complete the sale.
Then you did not stick to the time schedules. Default is there on your part also. Then where is the question?
Your lordship may kindly have page 52.
Sorry. Nothing more comes. That's nothing.
Lordship may kindly have page 52.
Page 52. What does it show? This is the payments you made.
Yes, my lord.
12 lakhs. 5, 10, 15, 1 lakh, 7 lakh, 10. What else? That's all.
Actually, my lord, we were.
What were the cutoff dates for the balance payment?
It was because of their deficient service, my lord.
No, but the agreement must have required you to make
Clause
payment.
11.
They didn't come forward, my lord.
No payment.
No payment after 2016.
But they didn't. My lord, loan was sanctioned and then loan was rejected, my lord. They didn't.
Nothing. 2016 to 18, you did nothing then.
My lord,
January 2016 was your last payment.
yes, my lord.
December 2018 is your
They
complaint.
didn't come forward to perform their part of the contract.
No, you should have amount for the schedule.
Where is the agreement schedule? When were you supposed to make the payments?
In fact, they didn't come. They didn't come forward for registration.
No, don't want to answer the question, counsel. There's nothing we can. Sorry, in any event, it's hit by the moratorium. There's nothing we can do.
My lord, loan was approved twice, my lord, and then it was
They
rejected.
granted were there two appellants?
My lords, they are both connected companies. Both are BCIL.
And which one is the SRA now?
My lords, my instructions are where that both are under the.
I see one is a branch office, one is.
One is a branch of the.
All right. The appellants, comma, BCIL Z RIA Properties Private Limited, comma, the successful resolution applicant, comma, is agreed by the order dated 5/3/2025, passed by the High Court of Judicature at Madras in WP number 10749 of 2024. By the said order, I see you need to go back to the NCDRC, is it?
And also NCDRCs because NCDRC, by its order of 31/2024, had rejected on the ground of delay.
So
and
you
that
need
was
to go
affirmed
back
by
to the
the High Court.
NCDRC. We will only make this order.
Well,
Yes, by the said order, the High Court confirmed the order dated 31/2024, passed by the National Consumer Disputes Redressal Commission, New Delhi, in first appeal number 591 of 2023. Refusing to condone the delay on the part of the successful resolution applicant in preferring an appeal against the order dated 11/10/2022 passed by the State Commission, by the Tamil Nadu Consumer Dispute Redressal State, what is that? State Commission.
State Consumer Dispute Redressal Commission.
SCDRC, State Consumer Disputes Redressal Commission, Tamil Nadu. Full stop. We may note that by order dated 16/10/2025, the court granted stay of further proceedings. 16/10.
16/2020.
Stay of further proceedings in EA number 30 of 2023, pending on the file of the Tamil Nadu State Consumer Disputes Redressal Commission, Chennai. Full stop. We may, a few crucial facts would be relevant for the purpose of, for the disposal of this appeal. The corporate insolvency resolution process against the corporate debtor. What is the name of the corporate debtor?
Look, BCIL is the corporate debtor. The successful applicant is Aisho Dreamlands.
Like this.
Name of the corporate debtor is BCIL.
And the successful
resolution applicant
Aisho Dreamlands
stepped into took over the corporate debtor BCIL. The name of the successful resolution applicant is
Aisho Dreamlands.
Where do we find the name?
Well, it's in the order itself, it is there. I'll just point out the page. My lords may give me just a minute. I'll give the name.
There in your synopsis, no?
It must be there in the synopsis too. I had noted the page, but
corporate debtor. Corporate entities.
The SLP is filed by the.
In the name of the
it's the name of the same company only because it's now taken over by Aisho Dreamlands. The company still remains, my lords. My lords would find it in page C.
Aisho Dreamlands.
Aisho Dreamlands Private.
Mention it like this: Aisho Dreamlands Private Limited, comma, the successful resolution applicant, which took over BCIL Z RIA Properties Private Limited. Why are you describing it as represented by the managing director? You've been in the SLP. In the High Court also it's shown as represented by its managing director.
True, my lords.
2022.
My lords, my understanding is that once Aisho Dreamlands became the successful applicant, my understanding is that it has.
You become the managing director.
Please step into the shoes.
We approved NCLT approved your resolution plan in 2019 itself.
2019.
Very good. Then I'll dictate the whole order then. Aisho, comma, the successful resolution applicant that took over the corporate debtor, comma, BCIL Z RIA Properties Private Limited, comma, is agreed by the judgment and final order dated 5/3/2025 passed by the High Court of Judicature at Madras in WP number 10749 of 2024. Full stop. By the said order, the High Court confirmed the order dated 30/1/2024 passed by the National Consumer Disputes Redressal Commission, New Delhi, in first appeal number 591 of 2023, refusing to condone the delay of 105 days in the filing of the said appeal by the successful resolution applicant against the order dated 11/10/2022 passed by the State Consumer Disputes Redressal Commission, Tamil Nadu, in complaint number 16 of 2019. A few crucial facts may be noted for the purpose for the disposal of this appeal. The corporate insolvency resolution process against the corporate debtor at BCIL so and so was initiated on 9/8/2018.
2018, my lords, and moratorium was from 9th August 2018.
9/8/2000. That is the date of admission, is it not?
No, that is the date of, yes, the moratorium.
No,
Filing is also
9/8/2018, when an interim resolution professional was appointed. In effect, the moratorium under Section 14 of the Insolvency and Bankruptcy Code 2016 started operating from the said date. In terms of the said statutory provision, it was not open to any litigant to initiate fresh litigation against initiate fresh litigation or continue with pending litigation against the corporate debtor. While that being so, the respondent approached the State Consumer Disputes Redressal Commission, Tamil Nadu, only on 4/12/2018 with his consumer complaint against the corporate debtor in relation to the sale and construction agreement dated 25/1. When was your sale and construction agreement? 25/1/2016. 2016.
25/1/2016.
Unmindful of the statutory scheme of the Insolvency and Bankruptcy Code 2016, the State Consumer Disputes Redressal Commission passed ex parte order dated 11/10/2022, allowing the complaint case filed by the respondent and directed the corporate debtor to refund certain amounts along with interest and costs.
Compensation.
And costs. Upon finding out about the passing of the said order, the successful resolution applicant of the corporate debtor filed an appeal before the National Consumer Disputes Redressal Commission, New Delhi, along with a petition to condone the delay of 105 days on its part in preferring the said appeal. It is this application that came to be dismissed by the National Consumer Disputes Redressal Commission and was thereafter confirmed by the High Court vide the impugned order. Given the aforestated facts, it is clear that the very filing of the consumer complaint against the corporate debtor was hit by the moratorium order, and therefore the successful resolution applicant has an arguable point to be raised before the National Consumer Disputes Redressal Commission. The delay on its part is also not substantial, and given the fact that the order passed by the State Commission was an ex parte one, the National Consumer Disputes Redressal Commission ought to have been more liberal in considering the said condoned delay petition. The appeal is accordingly allowed. Condoning, setting aside the orders passed by the High Court as well as the National Consumer Disputes Redressal Commission, the delay of 105 days in the filing of that appeal number so and so is accordingly condoned. The said appeal shall stand restored to the file of the National Consumer Disputes Redressal Commission, and the same shall be dealt with in accordance with on merits and in accordance with law. (37) page.
And the impugned order.
Lordship, I am for the respondent. But we have already
Counter-
counter-filed everything.
You filed a counter only on 15th May. Anyone for the petitioner?
Petition, is it still pending? The petition, there is an interim.
I'm for the petitioner.
What happened to your red petition? Yes, Mr. Upadhyay.
Yes, Milord,
You received a copy of the counter?
I got counter just yesterday, Milord.
You want time?
And I want to file rejoinder, Milord.
Very well. You and counsel for
If
the.
Lordships permit me.
Yes,
Otherwise, I am ready.
No. If you wish to file a rejoinder, we won't deny you. There's an order of status quo in any way. Learned counsel for the petitioner seeks time to file a rejoinder to the counter affidavit of response number 1, which was filed on 15/5/2026. Needful shall be done within a weeks. Earlier interim order of status quo dated 17/10/2025 shall continue to operate in the next year based on 13th August.
Highly obliged.
My lords, in 38, I am appearing for the petitioner. My lords, it appears that the respondents have not filed a
Filed
counter.
a counter till now. Who's appearing? Yes, Mr. Satvik. Yes, Mr. Satvik, you'll have to unmute yourself.
Yes, my lords, I am appearing on behalf of respondent, my lord. My lord, the main counsel was in personal difficulty, therefore he had moved an adjournment letter.
No
My lords,
adjournment
the
letter.
counter is ready. If my lords may grant me 2 weeks' time,
Very
my lords, we can file the counter affidavit.
You're appearing for both the respondents.
Yes, my lords.
Very well. Mr. Satvik and Mr. Learned counsel for the respondent seeks some more time to file a counter after usual order.
My
List
lord,
on-
there is only one clarification.
Yes.
The advocate on record who has filed the Wakalatnama in item 38 has not filed the Wakalatnama in 38.1, which is a connected matter. So we just want to clarify as to whether Mr. Satvik is appearing in both the
Are you
SLPs
appearing
or
in
not.
both
Yes, in
matters,
both,
Mr.
in
Satvik?
both matters.
Very well.
38 and 38.1, both.
Appearing in both cases seeks time to file a counter. Usual order. Earlier interim order dated 5/12/2025. Only in one case or in both?
In both the cases,
In
my
both,
lords.
my lords.
Very well. Shall continue to operate in the next hearing. List on 18th August.
18th August. Highly obliged.
39, respondent is not served.
Your Lordship, may kindly grant pass over in this matter, Your Lordship.
Respondent is not served, counsel.
As per my instructions, Your Lordship, respondent has been served, Your Lordship. We will be filing our service affidavit of service, Your Lordship.
Then you'll have to file it because we'll go by the office report which is dated 15th May and which says that service is not complete and you've not filed an affidavit in proof of dusty service.
We will file, as per my instruction, we will
Counsel
file
for the petitioner take some time to take necessary steps in relation to unserved sole respondent. Earlier interim order dated 6/1/2026 shall continue to operate till the next hearing, same date, August.
oblige Your Lordships.
My lord has listed it for hearing at the end of the board. If my lord wants, I'll start the matter, my lord.
You'll be able to argue online.
My lord,
Who opposes you though?
tomorrow, day after tomorrow, if my lord, I be given physical, because
No, your
some
voice is
document-
quite clear, Mr. Tiwari.
quite clear. Then
Your voice is quite clear. If the other side is also equally clear, then we can hear both of you. Then we'll take it up at the end of the list. Mr. Vinayak Sharma, let us see how good your audio is.
My lords, I'm led by. My lords, I appear. I believe at least my voice is clear enough.
Yes, you're also clear enough, Mr. Naidu. So we'll pass it over. We'll take it up at the end of the list.
my lord.
Adjournment is
Worship,
by the
it is,
learned counsel for
not
respondents.
counter.
For the respondents to enable filing of a counter affidavit, usual order. Earlier interim order dated 12/3/2026 shall continue to operate in the next hearing. List on 19th August. 42. 42 services not complete. 41 we have adjourned, madam. 42 services not complete.
My lords,
We have been respondent number 3, state, my lords, and it is a matrimonial dispute and petitioner has to serve. They have not
But he's
taken
not-
that.
Lordship, it is served to the estate, but not to the respondent number 2, Lordship. He is deliberately, Lordship, in item number 42.
Yes.
Is respondent number 1, who is estate, already served the copies, Lordship. He is appearing since from the first day, Lordship.
42, the.
0.1.
This is
Yes,
42 and
42.1.
42.1.
Yes, Lordship.
Well, state is not really a necessary party. What about the private respondent? You have not served.
Lordship, private respondents also served the parties. They appeared on 20th July 2025. Since then, they are not appearing, Lordship.
There was a counsel who had come, but after that, he is not.
Yes, Lordship.
Wakalat,
Since
therefore,
then,
you have to effect service of notice upon him. As per the
Yes,
office
Lordship.
report, service is not complete. Take steps, please. As per
Yes,
the
yes,
office report
Lordship.
dated 15/5/2020.
I will do it again,
The
Lordship.
sole respondent in TPC number 1373 of 2025 and who is respondent number 1 in diary number 18346 of 2025 still remains unserved. Necessary steps shall be taken in that regard. For the next date of year. List on.
Obliged.
19th.
Obliged.
43 IAs are there for withdrawal. IAs 43.
I received a copy of.
Lordship, I appear for the petitioner.
Do you want to transfer both cases or
Lordship,
one?
we are withdrawing. We're withdrawing both the transfer petitions.
Both cases. Very good.
Yes, your Lordship.
Criminal. In the criminal MP, there's only mention of TP criminal number 57. Have you filed another IA in the other one?
The other IA, Lordship, is the number is IA 132533 of 2026 for TP number
IA numbers?
146 of
IA numbers 134126 and 132533 of 2026 have been filed by the Learned Counsel have been filed by the petitioner in TP both the numbers. Mr. Tarkeshwar Nath, Learned Counsel, preparing for the petitioner, reiterates the prayer for withdrawal of both the transfer petitions. The transfer petitions are accordingly dismissed. Stay orders in both the transfer petitions shall stand vacant. 44, there is no appearance for the state.
My lords, I appear for the petitioner, my lords. In 44, my lords, the larger question pertaining to section.
Mr. Arjit Day is also appearing for the petitioner or for the respondent?
I'm in 44.
Please, my lords.
You're for the petitioner?
In 44.1, my lords. R. Suresh.
But
versus state of
one is
Karnataka.
appearing for the state.
The state has been served, my lords, but the wakalat has not been filed by the state in this matter yet, my
Will
lords.
serve their designated or standing counsel, please. Despite service of notice, the state of Karnataka has not chosen to enter appearance. Learned counsel for the petitioner is permitted to effect service of notice upon the learned standing designated counsel for the state of Karnataka.
We'll do that, my lords.
My lords, if I may, my lords. Serial number 44, my lords, the broader question is.
Whatever be the broader
has been
question, if we have
illustrated.
issued notice.
Please, my lords.
If we have
Please, my
issued
lords.
notice, we will need to hear the state, please.
Please, my lords.
Let
Grateful, my
the
lords.
state come forward, thereafter we'll see.
Please, my lords.
Twenty-seventh August. Forty-five.
No, I'm seeking your lordship's permission to approach the High Court and withdraw the present SLP, my lords.
Sorry?
I'm seeking my lord's permission to withdraw the present SLP and approach the High Court, my lords, in view of the Sompo General Judgment.
Yes, very. It's an old judgment, though.
Right, my lords.
Normally, we are not insisting on
My lords, if I may.
delegating you if it is an earlier order because Sompo came more recently.
Yes, my lord.
And you've already spent 4 years here. But it's your choice. If you wish to go before the High Court, that's your choice.
So if I may assist your lordships, on the last date of hearing as well, your lordships were of the opinion that since this has been filed in the year 2020 and Sompo General was in 2023, the present SLP is not unmaintainable. Subsequently, my lords, I have discovered orders of this honorable court wherein SLPs filed in the year 2021 have also been dismissed.
Oh, yes.
And
Very
liberty
well.
has been granted.
They'll only record it as your plea for withdrawal.
Please, my lords.
What is your name, Counsel?
Abhijit Singh, my lords. Abhijit Singh.
Abhijit Singh. Mr. Abhijit Singh, Learned Counsel representing Mr. Vishwapal Singh.
AOR.
Only Vishwapal Singh, is it not?
Yes.
Learned AOR, appearing for the petitioner, seeks permission to withdraw this special leave petition, reserving liberty to the petitioner to approach the High Court in the light of the law laid down by this court in so and so. That's all for general insurance.
Please.
Permission granted, the special leave petition is accordingly dismissed with the aforestated liberty.
Grateful, your lordships.
With liberty as aforestated.
Grateful.
बताइए अगला ही है.
I
46.
I am seeking a short accommodation, my lords, arguing counsel is in some personal difficulty.
Service is complete. Well, you want adjournment, is it? You're for the petitioner?
Please, my lords.
Adjournment is sought by the Learned Counsel for the petitioner on the ground of personal difficulty. Matter is accordingly adjourned, placed on 13th August.
Much obliged.
Yes.
Please,
47.
I'm appealing for opinion, my lords.
Hello, sir.
My lords, I'm seeking 2 weeks. My lords, I'm seeking 2 weeks time for filing of rejoinder.
Rejoined. Counter was filed in April.
My lords, we are finalizing it.
Very good.
My lords, may kindly grant me 2 weeks.
Learned Counsel for the petitioner seeks time to file a rejoinder to the counter affidavit filed by the respondent insurance company. Matter is accordingly adjourned.
I'm grateful.
List on same date, August. 48.
Much obliged, my lords.
48.
Yes, ma'am. Mr. Badiran. Yeah.
Well, it's item 48. I was praying for a Passover being led by Mr. Steve Singh.
Mr. C.U. Singh, is it? But R2, who's appearing, no counter has been filed by R2.
Well, it's actually on the last date, we had entered appearance for the first time in short time. There's a slight delay in receiving the final response from the corporation. If your lordships may accord us one final opportunity to then file a counter affidavit. It has not been filed.
You're appearing for R2, is it?
And I was not able to circulate. I'm appearing for R1 MIDC, my lords.
But on the last date, R2's counsel had asked for time.
No, my lords, R1. It was.
Yes?
Millers, I apologize. It's R2. Millers, I apologize. MIDC is R2.
MIDC, you're R2 then. Very good.
MIDC
Some more
is
time
R2.
then.
Please, Millers, one last opportunity may be given.
Adjournment is sought. Sorry, Learned Counsel for respond number 2 seeks some more time to file a counter document. It should be done without fail by the next date of hearing. Rejoinder thereto, if any. Not by the next date of hearing. Give 4 weeks. Rejoinder thereto, if any. If you file within 2 weeks thereafter. Same date in.
Grateful, my lords.
49, there's a letter.
9. Yes, my lord, I am appearing for the petitioner, my lord.
Have you?
Letter is filed, but in the meanwhile, yesterday they have actually filed the counter. So, my lord, counter, it may not be pure, your lordship. Would my lord skip it next week so that, my lord.
But they also said that there is a change in the incumbent. I don't know what that means.
Yes,
Counsel
but
is going to change.
Counter, my lord, is on record. So, my lord, I think that should be good enough.
Pursuant to recommendation of commission, my lord, appointment letter has already been issued.
In the first matter.
19
In the first matter.
First matter, yes.
What about the other matters?
But the other matter, that's what I'm saying in contempt petition number 3 of 2026. The counter is filed yesterday. So I have received the copy. It may not be before your lordship.
They've not issued an appointment order there.
No, but they are questioning some issues, so that will have to be heard.
Oh, I see. You need to file a rejoinder to the counter.
But I will file it within 2 days. Your Lordship may please have it next week.
Lord, the new incumbent may be impleted, my lord. Actually, this prayer.
I see.
Lord, he may, my learned friend may give the details. My instructing advocate will carry out the necessary.
Very good. We are informed that a counter affidavit was filed in
Contempt petition number 3 of
petition number 3 of 2026 yesterday. Registry may verify and put up the same. Rejoinder thereto, if any, may be filed by the next date of hearing. Details of the present incumbent shall also be furnished to enable the impeachment of the said incumbent in these contempt petitions. Based on, when do you want it, Ms. Nabre? August?
26th, my lord, or 25th?
Of?
25th of my lord, next week, my lord.
Lord, it will be virtual, my lord. It may be virtual, my lord. So your lordship may have it on a day when it's not virtual. My lord. That may be easier for me also.
Then 26th.
26th, the whole of that week will be miscellaneous days. You do remember that.
Yes, my lord. So,
in
other
miscellaneous days, I'm told, will all be online.
Consider having
Lord, this is not a matter where huge record is to be seen. So,
Lord, actually-
even virtual hearing will be good enough.
Lord, actually, my lord, I may have to show a chart, Lord. That's why I was just requesting
The
that.
second matter, some issues are there, my lord. So.
Very good. We'll take it
Lordship,
up
in
on
other matter,
22nd
counter has
July.
also been filed.
22nd July.
Grateful.
Grateful.
Sorry? 50 is also hearing matter. 51. Yes.
I'm appealing to the respondent numbers 2 to 6, my lords, the Mumbai Municipal Corporation.
Yes. Counter is already filed by you. You've already filed your counter, is it?
Yes, my lords, I have filed my counter affidavit and
Who appears for the petitioner? 51. No one? Pass over? Shall we pass over? Do you have any difficulty in the afternoon?
my lords may have it on some other day. I have a difficulty because
No representation for the petitioner. Learned counsel appearing for respondent numbers 2 to 6 states that he would have some difficulty in the afternoon session.
Yes,
The
sir.
matter is accordingly adjourned. List on 24th August. $52, no counter.
Whereas I beg to appear for the petitioner, counter is not filed. Not.
Who appears for
They
respondent?
filed
Yes,
Wakalat
Mr.
now.
Shubham? No counter.
But sir, I was taking 4 weeks time to file the counter, my lord.
And counsel appearing. You are appearing for the
For
respondent.
respondent number 1, my lordship.
Only one, is it?
Yes, my lord.
Not the other respondent.
No, my lord.
Very good. Then counsel appearing.
But because the respondents are also instrumentalities of state.
One is a private party, though.
Yes.
Learn counsel appearing for respondent number 1 seeks time to file a counter affidavit. Usual order. Earlier order stay dated 13/3/2026 shall continue to operate to the next hearing. Based on September 7th.
Obliged, my lord.
53.
Lords, in item 53, I filed my objections on Saturday. Lords, I'm not sure whether it has come on record.
You filed an application with a
Lords, I am
filed
for
a
the
statement
respondent.
of account.
Lordship, I am appearing for the respondent.
Oh,
I
you have
filed my
not filed
objection
it.
on.
That's what I've noted. The other
Yes,
side
so therefore-
statement of account is before us, but not yours.
Lordship, yes, I filed it on Saturday. Lords, it has not come on record probably. Lord, may I request Lordship to have it
Who appears
next?
for the applicant?
Lord, he's there online.
But this statement also, this statement is not really easy to understand because you've clubbed off all the amounts without taking into account the payments. Once a payment is made, you would have to appropriate it towards the interest due. You can't just you can't just club it date to date and quantify the.
My Lord,
Is there? Anyone is there online? No one.
yes, my Lord, counsel is appearing. I think he's not unmuted.
We don't see anyone also. 50.
No, I saw him there. I saw him there.
Anyhow, your statement.
Lords, my statement of objection may be allowed to come on record. Lords may have it after some time.
Yes. Counsel for the respondent states that his statement of account was filed.
Mr. Siddharth,
yesterday.
Mr. Siddhartha,
Mr.
speak up.
Siddhartha, your statement of account is not clear. You can't just club the dates and say we've been. You need to unmute yourself. We can't hear a word you're saying.
Lord, court officer will have to unmute him.
No, it's a-
Your side. The problem is at your side.
if he can hear you, just tell him what.
You'll have to give us the breakup of how you work out this account, because you have just clubbed the dates 22nd September 1998 to 19 January.
I'll file a fresh
2005
statement of
for
accounts, my lord. I don't know if I'm
calculating the
audible
interest
right now.
amount.
I've heard what's fallen from my lords. I'll supply a fresh
You'll have to
statement.
file a fresh statement of account. Learn counsel for
Just
the
tell him about the interest appropriation. Then he.
whatever
Lord, sir,
payments you
Lord, for that-
receive, you will
Lord,
first
may I
have to
submit for that?
appropriate towards the interest.
Lord, may I submit on that? Because, Lords, if Lordship will see his claim, Lords may kindly have annexure A file.
Let him file a fresh statement. We'll see your statement also. Then you can
Lordship,
tell us how you work it out.
Lordship.
Fresh statements of account shall be filed by both the applicant as well as the respondent, as we find that the applicant's statement of account dated 8/5/2006 is deficient.
Grateful, Lords.
List on. Third August.
Lordship, please.
54.
May I please minutes? Minutes, it concerns the appointment of an arbitrator. The issue falls in a narrow compass. Minutes, there was in 2008 a joint development agreement between me, the developer, and the respondents, the landowners. And that project had been completed. And in that process, minutes.
Then.
Little time perhaps. We'll take it
My
up
lords
in
could-
the afternoon.
After
We'll
That's
take
my
it up
lord's
after
indication.
lunch. Mr. Shankar Narayanan is opposing you.
Very well, my lords, we're ready.
Yes.
after the one hearing, we'll take this.
Hearings are there.
Sure.
One, no?
Two
Two.
hearings are there. This will be the third.
So, grateful.
55. Service is incomplete.
May I please, my lord, the respond numbers 8 to 18, my lord, they have.
I am applying and seeking the 4 weeks time to file the counter.
Sorry?
Seeking 4 weeks time.
My lord, respondent number
Which respondent are you appearing for?
9 to 18, they have also been served on Saturday, my lord, and the district court will upload the report.
7.
4 weeks
1
time.
to 7 already shown as complete. Unserved are 9 to 18. You're saying that they are now served, is it?
On Saturday, they have been served, my lord.
You will have to file.
But the court will be uploading the service report directly, my lord. They have not given to our client.
Respondent numbers 1 to 7 seeks time to file a counter affidavit, usual order. So the office report dated 16/5/2026 reflects that the respondent numbers 9 to 18 are still unserved. Learned counsel for the petitioners states that service has been completed insofar as these respondents is concerned, and that you have to file an affidavit and proof of this.
I will file, my lord. Otherwise,
that
they will
step
be
would be
filing
taken
directly,
in
my
that
lord.
And that steps would be taken in that regard.
Should the
List
4
on
weeks time be granted?
Okay.
Please, much.
Same date, 3rd August. $56.
My lord, I appear for respondents in 56. But I request some time to file counter, my lord, and argue the matter.
In which items, Mr. Dwarkana?
56 and
Counters are filed in some matters by the looks of it.
my lord, I appear in 56.1 and 3. The office report
You
shows
have to file.
No, I have not filed, my lord. Office report also shows it's not filed.
So in all those three cases, you need to file.
Yes, my lord. It's a common order of the High Court.
ASG, preparing for the Union of India, seeks time to file a counter affidavit in SLPC 8611, 9257, and 9293. Is that correct?
Yes.
Of 2026. Tuition water.
My lords, I appear in IA number 121279 in the same batch.
Which one?
IA number 121279.
That's an intervention application.
Yes, my lord, intervention application. Gujarat
Who appears
Tobacco.
for the petitioner?
Patel Products is the
Milords,
petitioner.
I'm appearing in item 56, 56.2 and 56.3, my lords. I'm the petitioner in
About
these
the
three matters.
intervention applications. Some
No, I have no
associations
objection.
want to come on record. Yes?
But
You
I
have no
have a
objection.
counter to that also, my lord.
How can you oppose it?
No, my lord. Because they are also asking, my lord, even though they are not concerned with the same project.
Perhaps. They are espousing the same cause as Patel Products.
Yes, my lord.
No,
We are in Tobacco Merchants Association, Gujarat Tobacco Merchants
That's
Association.
the reason why I have to oppose it. My lord, according to them, their product and line of
Say that they should not be implicated when the petitioner's counsel has no objection. Petitioner's counsel is the dominus litis, is it not? Petitioner is the dominus litis. Ms. Vanita, you have no objection to the.
I have no objection, my lordships. I have no objection.
Come on record, then we'll hear them also.
Grateful, my lords.
Oh, the merrier, Mr. Dwarapnath.
Milords, interim order may be continued, my lordship.
Yes.
Please to grant no order, no coercive steps, my lords, on the last date. Your lordships may kindly continue.
We will only hear you, Mr. Mehir. We will not be granting you relief here.
Yes.
Because only Patel Products has gone through the process.
Yes.
You can't come here directly and ask for relief straight away.
No, my lord, there is no interim stay also that I'm asking for. There is no order against me, but I'll be affected by the order in Patel Products and hence I wish to enter.
To that extent, yes, you're entitled to be heard, but not beyond that.
Very well.
Again, interim order dated 12/3/2026 shall continue to operate insofar as the petitioners are concerned. Intervention applications are not opposed, hence ordered. And the interveners are brought on record as interveners and not as parties to the litigation.
Obligation.
Grateful, my lords.
Brought on record as interveners and not as parties to the litigation to enable them an opportunity of hearing and no more. '57, no counter.
So we have, on behalf of respondent number 1, I have filed my counter on Saturday, so it won't be before your lordships. I also have some additional documents to file, so if your lordship can put it next week, we'd be ready, my lord.
I beg to appear for the RP. We filed an affidavit showing the current status of the proceedings. So, my lords, post 23/3, we had invited claims. The COC stands constituted.
So you want to file a status report?
My lords, we have filed an affidavit bringing on record the current status.
You already filed it? Yes.
Yes, my lords.
Yes.
May I make one small submission without prejudice?
Yes.
Your lordships would note that the impugned judgment was arising out of basically where I said that I would bring in, as a former director, I would bring in the money that is required to settle the matter. There's only one creditor. That's why eventually, based on a settlement, the Section 12A withdrawal was permitted. After which the period of reckoning for me to bring the money in was the substantial question in the impugned judgment. I brought in 120 crores. I had 90 crores still to be left. By virtue of the stay your lordships have passed on the first day, the CIRP continues. That pretty much puts paid to any option I have of bringing that balance money of 90 crores. My only concern is if it gets pushed off for a long date, I may not be in a position to argue regarding the revival issue at all. So even while the COC stands constituted,
why don't you deposit that money if you have it?
The problem that I had was the land documents The original land documents were not available with the authorities. They had to apply, Noida had to apply to get the duplicates. That is why my third party, which is Birla, with whom I entered into, they were willing to give me that money. If your lordship give me a little time, I'll try and deposit that money. If your lordship give me the liberty, I'll try and deposit it in court.
My lord, the amount has changed today, my lord. It's not the settlement amount. It is reverted back to the original amount. Can you hear me?
My lord, a detailed hearing had happened.
Lord, once, my lord, the settlement fails, it reverts to the original amount, not to the settlement amount.
Settlement amount is how much?
The entirety of it was 210 crores, of which I paid 55, then I paid 40, and then I paid 25. Now, the date
95, also 120. Then
120 has been paid. Now, the remaining 90 was still to be paid.
Right.
But in the meanwhile, the CIRP got revived by the allowing of the application, wrongly recording that I had conceded. I had never conceded.
No, my lord, I am sorry. That not ordered.
Allow me to complete,
Yes,
sir.
yes.
Mr. Dhawan, I'm not interrupting you. Allow me to just complete. We strongly contested it. We filed an application saying, please don't record that I have conceded. I have not conceded. That application was allowed only partly, saying instead of considered, it used the words agreed to. I said, just give me the time. I've shown my bona fides. I've come up till here. And the clear fact is there's one creditor, only one. Now, in my view, my lords, that revival question could not arise.
settlement, when were you supposed to make the payment?
I'm sorry.
When were you supposed to make the payment under that settlement agreement dated 9/5/25?
There is a schedule. 55 had to be done in advance, which was done. 40 was to be done at the time of the agreement, which is 9th May 25. I did that 40. I was supposed to pay 25 further within 30 days of the commencement date. The commencement date was the date on which the NCLT allows withdrawal of the withdrawal of the insolvency proceedings. That was allowed on 31st July 25. We took the date of reckoning as the date on which that order was uploaded. The order was uploaded sometime on the 26th of August. We made the balance payment of 25 within 30 days thereafter, which is 25th September 25. So by 25th September 25, we believe that we had complied with what was required to be complied with by then. That is, within 30 days, we had finished 120 crores had been deposited.
No, but you said within 1 month from the date of allowing of the 12A application.
Correct. So
the 12A application was 31st July.
So what the date that we took, right or wrong, my lords, the date that we took was the date of the uploading of the order. That date was only 25 days later. So that
Thereafter, the next payment after that was when?
90 days of that commencement date. 90 days. So
90 days.
Yes. That 90 days would take me to 26th November 2025. But well before that, on 7th of September, they filed a revival application. And I answered that revival application effectively saying you can't have a revival when the settlement has not been incorporated in the award.
What stopped you from making the payment before the NCLT allowed that application on 7th January?
The problem is that the third party with whom I had entered into, which is Birla said, we want the original documents of the land. Those original documents of the land were not with me. They were with the bank. I was trying with Noida. I was trying to get those original.
You want an early date now?
I only don't want the CRP to be precipitated because I feel that I have a fairly solid argument I can take before your lordship regarding this.
Pay them interest for the delayed payment.
My lords, the claims that we have received as RP.
Just 1 minute, Mr. Resolution Professional. I will take instructions on that. I'm sure once we have reached 120 and we have to go to 210, a few more on that side won't be a problem. My only small submission is if there can be a status quo on the CRP.
No, I'm sorry, my lord. I'm sorry, I have something to say on this.
At this stage, we can't do that.
My lord, may see, my
The
lord,
claims as on date are 732 crores of the financial creditors, my lords.
No, that's with interest counting on one on top of the other.
Component, my brother has just worked it out. It's quite substantial.
correct, my lord, correct.
45
That's what I'm
lakhs
saying.
a month itself. At 6%, that too.
My lords, as on
And
date,
my lord,
claims
my lord,
filed
my
are
lord,
732
Additional
crores,
amount
my
I
lords.
can take instructions on. If your lordship
No,
give me
no,
the
no.
majority,
We'll just give you a short date, so let us see.
my lord, the interim order to
Spot number
continue. my
one
lord.
is stated to have filed a counter affidavit. However, the same is not on record. Registry may verify and put up the same. What, anybody else needs to file documents?
My lord, the rejoinder has to be then filed because we have to
Rejoinder
rebut, my
thereto,
lord.
and it may be filed by the next date of hearing.
And my lord, the interim order to
Yes.
continue, my lord.
Earlier interim order dated 23/3/2026 shall continue to operate to the next hearing. Based on July 15. We pick
Obliged.
it up on
So deeply obliged, my lords.
Obliged.
very well.
So deeply obliged, my lords.